All right, good morning, everybody. This is Brian Lysing with Financial Brokerage. Thank you for joining our monthly webinar, Death and Taxes, Estate Planning for the Middle Market. I want to thank everybody for taking some time out of their day to join us here. We'll try our very best to keep this to about 20 minutes or so with a little time left over at the end for questions and answers. All of your lines are muted, but you are able to ask questions on the screen. We'll get to those at the end. You can type in your questions, and I'll get to as many of those as I'm able to at the end of the session. So thank you for joining us this morning here. We're going to talk about estate planning for the middle market. You know, recently Congress changed the way the federal estate tax works. Right now, you've got to have if you're a husband and wife, you're not subject to the federal estate tax until your estate is worth more than $10 million. You have a $10 million exemption between two people. So that really knocks a lot of people out of the picture for traditional estate planning or estate tax planning. But I tell you what, there are a lot of other taxes out there and other things that can cause delay in moving your assets from one generation to the next. So in the broad scheme of things, estate planning is not just about estate taxes. It's really about transferring assets where we want them to go and when we want them to go there. And this really applies to all estates regardless of their value. So we'll be reviewing some real basic ideas you can use with anybody regardless of the size of their estate. Now, I've kind of broken down estate planning into 3 levels here, and this is so I can keep them straight. And you can kind of go up the economic ladder here with these ideas we'll be discussing. But on a very simple level, we'll be discussing beneficiary reviews and how those can help folks. On a little higher level, we'll start the discussion about wealth transfer. And then I'll touch a little bit on estate tax planning, because that is still out there, and it's still a worthy pursuit if you've got clients at that income level right now. To start with, on the very simple or basic level, I wanted to cover some real common beneficiary mistakes that people make out there. In fact, spoke to or had a chance to listen to an attorney who does a lot of work with life insurance. This is a few years ago, and he said the biggest problem he sees in his office isn't estate plans that aren't done right or business plans that aren't done right necessarily. You know, it's not the high-level stuff. It's improper beneficiary designations on life insurance policies. These could be $50,000 or $100,000 policies, people that maybe are just middle income, and those are the most common problems they see. And thankfully for us, those are also the easiest problems to fix. So we're going to discuss a couple of common beneficiary mistakes at the individual level, and then also a couple that are at the business level and applies to business cases. So to start with, what's the problem with naming your estate as the beneficiary? I'm sure we've all seen this. I saw it when I was out in the field. Ask somebody that question on the application, who would you like as your beneficiary, and they'll tell me their estate. Or commonly this happened with the secondary or contingent beneficiary. They'd name their spouse primary, contingent, just name my estate. You know, just have it go to my estate and they'll settle it. Well, you know, there's some problems with that. If your death benefit does go to your estate, that means it's going to go through probate. And probate, if anybody isn't aware, it's just the whole process of proving the will through the courts. You have a will, it has to go to the courts to prove that really was you and it's a valid will. Well, that whole system takes time, on average about 6 to 9 months. Also creates unnecessary attorney fees. You know, you need an attorney to send that will through probate. And the attorneys usually, in most states, will their fee for doing that is a percentage of the total assets that are going through probate. Now, why would you want to make that number bigger and give more of your wealth to the attorney? Wouldn't you rather pass it on to your family? That's where you really want it to go. So naming your estate as a beneficiary is a big problem out there. Causes, again, unnecessary fees and certainly causes some delays. So what's our answer to that? What's the alternative? Well, gee, simply name a living person as the beneficiary, whether it's primary or contingent, or you could also name a trust as the beneficiary. Now, there are some fees involved with setting up a trust, but you know, potentially you're looking at a flat fee there for the trust versus a percentage of the total estate later on. And I think I'd probably take my chances with the flat fee. Yeah, you know what you're having to pay. And within the trust, you can dictate how the money is paid out and to whom and under what circumstances and when and a whole bunch of things. You could also name a charity as the beneficiary or contingent beneficiary of the policy. Just don't name the estate. Now, another common problem we see, and I saw this when I was out in the field and get calls on this a lot, where folks want to name minor children as beneficiary on the life policy or more commonly as the contingent beneficiary. Well, that's great. We understand that the reason people buy life insurance is so that their children have the funds growing up. They have the income that if you're not around, at least the income would still be there to provide for them until they're able to go to college and get jobs of their own. Well, if you name the minor children as beneficiary, here's what's going to happen. A court-appointed guardian is going to be needed to administer those funds. You can't have a 10-year-old with a $250,000 bank account. It just won't work. So whoever the court appoints has to be willing and able to serve. It can't just be somebody they pick and the person doesn't want to do any work. The court's choice might not be the first choice of your client. You might have a person in mind who you know is going to take good care of your kids. The court has no idea the relationship between you and your children and whoever this guardian may be. There's some relatives you trust, and there are probably some other relatives that you don't trust as well. The court might pick the wrong one. You're not going to be there to tell them otherwise. You're going to be dead. So why not make that choice yourself? Don't put that in the court's hands. And you may even see some problems with young adults who maybe they're not minors anymore, but they're just barely over the age of majority in your state. They're 19, they're 20, they're 21. Do you really want to trust a 21-year-old with $1 million death benefit? I mean, it's going to go to shoes and parties and new cars, and they're not going to have anything left by the time they're 25. So you want to name a responsible person as the beneficiary, not minor children. Let's see here. Well, if the computer would cooperate, we'll go to the next slide. There we go. The alternatives to naming minor children, again, you can name a trust, and you can spell out exactly who's going to be in charge of the money, how it's supposed to be spent for the benefit of the children, and how much per year they should be receiving. And I think something that would be even simpler, though, is to just name a living relative that you trust. Again, it can be an aunt or an uncle of the children, or maybe a grandparent. Again, somebody who you know very well, and they're going to be able to take good care of the children. Now, moving on from the individual beneficiary mistakes, I'm going to talk about a couple business insurance-related beneficiary mistakes that I see a lot over here at Financial Brokerage from people calling in. And one of the things that we see a lot is in a key person type policy. This is where a business takes out a life insurance policy on an employee who is key to the everyday operations of that business. Maybe it's an IT person that they're the only person who knows exactly how the computer system works. And if they're killed in a car accident, guess what? The business can't function because that one person knew all the codes and passwords and everything. So you're going to need a little money to hire someone else in there to find all that stuff. It could be a key salesperson, who knows? But that's the reason businesses take out key person life insurance. Now, a lot of times a business owner tries to take a tax deduction for those life insurance premiums. And why do they do this? Well, it's usually because a buddy or a friend of theirs told them that they could do it. Yeah, you can just deduct that. They didn't consult with their tax person or CPA. A friend said you can do it, so that's what they go ahead and do. Now, the problem here is if the business is also the beneficiary, which it usually is in a key person plan, then that death benefit becomes taxable to the business. If you take a tax deduction up front, then the benefit becomes taxable. If you don't take the deduction up front, you pay for it with out-of-tax dollars, or after-tax dollars, I should say, then your death benefit is completely tax-free. Real simple solution to this one. Do not deduct the premiums. Can't get much easier than that. But if you're in front of somebody in a business insurance situation, asked to review their key person life insurance policy and see how they have it set up, and then ask them what they're doing with the premiums, if they're deducting that, and you're going to be able to save people a lot of money down the road should somebody pass away. Now, the second business entity beneficiary problem we see, and this one isn't quite as common, and the consequences are not quite as great, but it involves a buy-sell agreement. And in a buy-sell agreement, you've got owner A and owner B. They agree to sell the business to each other should one of them pass away. Well, we see people trying to do, first and foremost, is to have the business pay the premiums and then also be the beneficiary of the policy. And you can see in the graphic, the business pays the premiums to the insurance company returns the death benefit to the business. That's great. It does what you want. The business now has money to buy out the heirs of the deceased partner. Well, there is a little bit of a problem with that, in that now, I'm going to use an example here that says we just have two owners, and they both put in $50,000 of their own money into the business. And let's say the business hasn't grown at all. So $50,000 plus $50,000. Now we have a $100,000 business value. Well, if they do the buy-sell arrangement like we just showed, the business is still worth $100,000, but owner A, who is now the sole owner, still has his $50,000 basis in the business. Yet the business is worth $100,000. It hasn't grown $100,000. It was always worth $100,000. But if owner A goes to sell that business, since his basis was only $50,000, he's going to see a gain of the other $50,000. That's taxed at capital gains rates, and he really didn't grow the business. It was always that value. So now he's paying tax on something which he really shouldn't have to pay taxes on. So what's our solution for this? Well, we need to have each owner own and pay for a policy on the other owner's life. Owner A owns a policy on B, B owns a policy on A. The premium dollars go to the insurance company. The death benefit goes back to the owner that is still living. And what that does, now the owner that is left living receives tax-free dollars from the insurance company. They now have money in the form of their own personal funds to buy off the family of their deceased partner. And now they have the entire basis in the company. Owner A started with $50,000. He got $50,000 tax-free from the insurance company to purchase owner B's shares. Now owner A owns 100% of the company, but he also has a basis equal to the value of the company. So that's the way you want to do it, where the owners own policies on each other. About the only time where it makes sense to have the business own it is if you have a lot more than two owners, and it becomes cumbersome for each person to have a policy on the other one's life. In that case, any capital gains that would be there would not be so great, and it might just be easier for the business to own it. But most cases where there's only two people, have them each own the policy on each other, and you'll avoid unnecessary taxation down the road. Now, some prospecting tools to help with beneficiary reviews. American General has this piece here. It's a producer guide to beneficiary reviews. It takes you through step-by-step things to look for, wording that you should be using on the beneficiary portion of an application. And there's even a fact finder in there that you can use to help your clients when you're reviewing existing beneficiary designations on their policies. And another little idea I picked up from somebody a little while back, when you're taking an application for a client and you get to that portion where you're asking them about the beneficiaries, well, we've now learned what to put on there and what not to. So let's say that we're to the point now where we're really putting real life people down who are not minors. And a lot of times this sort of a letter here would apply when you have adult children of the policy owners listed. Don't just put their names down. Ask the client for a way to contact those beneficiaries, their address, their phone number, their email address, and let them know you'd like to send them a letter just stating that they are now the beneficiaries of a life insurance policy, and that you want to make sure that they know who they can contact when your client passes away. Because if your client has passed away, they're not going to be able to call you to say, hey, we have this policy and we need to get the death benefit paid out to our heirs. It's the heirs that need to know about that life policy. So if you can be proactive and let them know that, it's going to smooth out that process when they do pass away. Maybe the heirs can't locate the policy, don't know where it is. Let them know that you have a copy of on file or can get to it. You've got the policy number listed in the client's file somewhere. And then, in the process of giving them your contact information, you want to let them know that you are also available to help them out with their insurance needs, whether it be life insurance, long-term care, or maybe with retirement planning. So, this is a prospecting opportunity when you're putting down the beneficiaries on a life insurance policy. Find out a little bit more information, and those folks might become your next clients that you get in front of. So now moving on to the next level of estate planning. I call this the intermediate level. We spoke about earlier with beneficiaries, that applies to anybody, any income level, whether they have a $10,000 policy or a $10 million policy. And now we're going to get up, move up the food chain a bit to people that have got some extra money laying around. These are generally seniors, and they've done some planning for retirement. In fact, they've planned so well that they've got extra money sitting around that they're not going to need for their retirement needs. And so we're thinking here of clients that might be taking required minimum distributions, and they don't need all that money. Or they've got some CDs just sitting at the bank. They're intended for their heirs. They don't need to touch them all. They keep renewing them every 5 years or however long at what seems like a negative interest rate these days. So, there's some potential problems with this that involve unnecessary income tax, either paid by themselves or paid by their heirs. In fact, in the case of the required minimum distributions, a lot of times people that are taking those because they have to, what are they doing with the money? Well, they're reinvesting it somewhere else. And wherever they're reinvesting it, either they're paying taxes every year, or if it's in, say, a deferred annuity, someone was going to pay taxes on that every year. And there's really no need to do that. Let's put that somewhere where the money can be used as leverage for the clients. And our friends at ING put together this graphic a while back and really illustrates that scenario right here. We've got Mr. Wilson, and he's got $300,000 in the CD right now. In fact, he takes $7,500 a year income out of that. Of course, he's got to pay some taxes on that every year, and what he's left with now is $4,875. So what ING here is proposing that we could do with that, and you could really use any carrier, but they're proposing that we take that money and move it somewhere else. So we move $78,000 of it into a single premium immediate annuity, and move $105,000 into a single premium life insurance policy. Now, after doing all that, Mr. Wilson still has $117,000 left to do with whatever he would like. But that $78,000 we moved into the SPIA now gives him an income of $5,460. That's after taxes comes out to that $4,875. That's exactly what he was getting before. So he still maintains the same income, and the $105,000 purchases a life insurance policy, and that was in the amount, in this case, of $300,000. Now that goes completely tax-free to the heirs at that time. So the heirs get the same amount, he gets the same amount of income, and guess what? He's still got $117,000 just left over as spare change in liquid assets he can use for whatever he would like. So that's one example of putting the idea of wealth transfer into action for a client. And another example here we could look at, let's take a look at Mrs. Wilson. She's a year younger, and I stole this idea from our friends at Mutual of Omaha. She's got $50,000 sitting in a CD, and this is money that's intended for her heirs, assuming 3.5 interest, which is probably a little high, and a 25% tax bracket. After 20 years of that 50 grand sitting in a CD, $83,000 is going to pass to her heirs. And so, I mean, that's a nice gain, but it takes her 20 years to get there. Well, assuming she doesn't need this money at all for her retirement income, why don't we move that 50 grand to a single premium life insurance policy? Now it doesn't matter what kind of interest rate she's getting on it, and there are no taxes to be paid on this. I ran some numbers, and $50,000 for a 64-year-old female in good health will get her close to $100,000 of death benefit, and she doesn't have to wait 20 years for it to get there. There's no taxation on that. That 100 grand passes to her heirs immediately upon death, whether she dies next week, or 20 years, or 30 years, or what have you. So definitely an improved situation for money that will not be needed for regular retirement income. So again, we've not necessarily avoided taxes, but we've certainly found another way to reduce taxes and reduce delays. Some prospecting ideas you can use to get here to these wealth transfer conversations. When you're sitting down with a client, there's a simple question. I stole this one from my annuity counterparts here. Simply ask, where do you keep your safe money? The money you can't afford to lose in the stock market. And they'll tell you, and that will help you locate where these funds might be. Ask them what the purpose of this money is. They'll tell you what funds are needed for retirement income, what's set aside for emergency purposes, and quiz them a little more on that too, because that can lead to a long-term care sale, because that's really the real emergency. There's no other household emergency that they need $100,000 for. And another thing you can do is ask them to bring out their latest tax return. You can go through there. You're going to find all of their assets, because they have to list them all out there and review that 1040 form. Another resource to use would be ingwealthtransfer.com. They've done a great job of pulling together various pieces of information, fact finders, and case study examples that you can use with your clients as you get in front of them. Now, I'm going to touch briefly on what I would call the advanced level of estate planning, and this third part of the webinar is going to go really quick because I didn't want to delve into this too much. The new laws I mentioned at the start says that as a couple, you can exempt up to $10 million of assets. Anything above and beyond that is subject to the federal estate tax. Well, if you're getting close to $10 million, what should you do? Well, start gifting money to relatives, to charities, to your local insurance agent. Always put yourself out there as a willing recipient of their funds if they don't want to have to pay the estate tax. Let me know if it works, by the way. Now, at some point in time, people can only give away so much money, and then they're going to still be stuck with having to pay the federal estate tax. So what we usually do is use a survivorship policy in the case of a husband and wife. We put that inside of a irrevocable life insurance trust, and now the funds have been created upon the second death to pay any potential estate tax that's due. Now, if you want to get in front of those folks, look for people who own businesses, people who own a lot of property, even if they don't look like they have a lot of money. I know there's a lot of ranchers and farmers in the middle of the country where land is very high priced right now. If they die, the right people might have an estate tax problem, and in general, any high net worth individuals out there. So, recap in general, we discussed 3 levels of estate planning, starting with the very basic beneficiary reviews. You can use these ideas with anybody out there, clients of any income level. And a little farther up the economic chain, we start looking at wealth transfer opportunities. You've got to question them about their money and the purposes. And then finally, if you do come across those folks worth over $10 million as a couple, you get into the more traditional estate tax planning. And I'll take a look here and see what questions we have. Keep in mind you can type them at the bottom of your screen there. And we'll see what's coming up. All right, we've got a question or maybe a statement here. If the business creates a taxable death benefit, it can be offset by using the funds for a deductible expense like hiring a replacement for the deceased, and I would suppose that's true. But you know, why not? You're going to get that deduction anyway. Why not have it offset um, another taxable event out there? It just makes so much more sense to not deduct the premiums. Let's say your premiums are $2,000 a year, and then you're going to receive $500,000, which would all be taxable. I think over time you're going to pay less taxes by using after-tax dollars for that premium versus receiving a death benefit that would be taxable to the business there. And we'll see if we have some others out there. I'm not seeing them just yet. Be sure and watch your emails and also our training calendar on our website, fb-inc.com. For next month's webinar, I plan to focus on college planning, different ways you can use life insurance to help clients provide the funds to send their children to college. And I'd like to thank everybody for joining us this morning for Death and Taxes. Feel free to call me throughout the day and weeks to come, too, if you have any further questions at 800-475-5555, and my extension is 3371.